May it please the Court. Ron Reddick on behalf of appellants Clam Lake Township and Haring Charter Township. In light of the consolidated proceedings, Your Honors, I wondered if it's possible for me to get a 15-minute notice when I know to change gears to the separate docket number.
You have to keep track of your own time.
I'll keep track of my own time then. Thank you, Your Honor. Starting then with docket 151-800, the question of Casco Township and its jurisdictional holding. Your Honors, in addressing this case, I'll start with taking somewhat of a risk, if you will, and that's to ask you to accept the underlying premise of the Boundary Commission's and the other appellees' position. And that premise is that the legislature made a bad policy choice when it allowed township-to-township Act 425 agreements to prevent annexation, and that the Boundary Commission therefore needs to have the implied authority to address that situation by invalidating those township-to-township agreements whenever they believe that economic development would be better furthered by annexation. And I ask you to accept that underlying premise, not because I agree with it. I don't. I ask you to accept it because it doesn't matter. Because if you accept that premise, the only necessary conclusion that follows is that the Boundary Commission and the other appellees are simply in the wrong building. They need to go about 7 blocks east to the legislature and bring that argument to their representatives. They would need to ask their representatives to introduce a form of bill that would accomplish, to borrow directly from the Casco Township opinion, that would create a more logical result where the Boundary Commission would have this authority, or to borrow directly from the Attorney General's brief to create a bill that would reflect the wisdom by which the Boundary Commission would have this type of authority. And that's necessarily the type of policy argument that the appellees have to advance, because I do submit to this Court that there is no jurisprudentially sound manner, at least not under the existing precedents of this Court, to reach a conclusion that the Boundary Commission has the authority to review, decide the validity, and invalidate Act 425 agreements. And I say that because under at least the past century of decisions from this Court, the clear and unmistakable rule that has been established is that administrative agencies have no authority that is not expressly granted by clear and unmistakable statutory language. But what we have here is a statute, Act 425, where the Boundary Commission is empowered to do nothing. They're not even mentioned. And so the plain and unambiguous language of the statute necessarily leads to the conclusion that the Boundary Commission is impotent to do anything regarding Act 425 agreements. I'm sure they don't like that. If I was in their position, I'm sure I wouldn't like it. But that's beside the point. As the MTA does a fine job of pointing out in its amicus brief in this matter, the whole point of Act 425, as its history shows, was to keep the Boundary Commission entirely out of the realm of Act 425 agreements. And so this was not an accident that the statute was written this way. It was done on purpose. And so unless this Court intends to undo approximately a century's worth of its prior precedents about the very limited authority of administrative agencies, Casco Township's jurisdictional ruling needs to be overruled, and likewise, the Boundary Commission's decision in this matter needs to be voided for lack of jurisdiction. Now, Casco Township itself seems to recognize that it lacks statutory basis for the conclusion it reached, and therefore went extra statutory, if you will, in its analysis. Well, that's improper on its face, but even if you go on to review the extra textual reasoning they applied, it needs to be rejected. Casco Township tried to look at whether, well, what it said is the Boundary Commission cannot perform its function of resolving a petition if it doesn't have this authority. Well, that just really misses the whole point, because the whole point of these Act 425 agreements is that the Boundary Commission is not to resolve them. To the extent they resolve them at all, it is only to reject them. And it is not true at all that they need to undergo some adjudicated process through multiple hearings, public hearings and whatnot, to reach this conclusion. In every case where an Act 4...
Counsel, when does an Act 25 agreement become effective?
Well, thank you for that perfect segue, because that's just what I was going to read, Your Honor.
It's just another service I provide.
In every... I'm sorry.
Nothing else.
In every case where there's an Act 425 agreement in place, the Secretary of State's office, in fact, makes a determination when it's in effect and submits and generates this type of letter that goes to multiple state agencies. It's in the appendix at page 723.
What provision of the Act am I looking for to determine what causes the effectuation of an Act 245 agreement? 425. 425, I'm sorry.
Yes, it's section, it's MCL 124.30, Your Honor. The conditional transfer of property pursuant to a contract under this Act takes place when the contract is filed in the manner required by this section, which is filing with the county clerk and the Secretary of State. And again, the Secretary of State always issues a letter. In this case, it's in the appendix. It acknowledges the receipt of the Act 425 agreement and says, I quote, in this case, the receipt date was June 10, 2013. The receipt date is the effective date of this boundary change.
So what I'm now, I thought that was what subsection 30 meant. Now, so I'm really curious about Casco's decision and several others that seem to defer to the Boundary Commission the authority to delve into the propriety or the statutory compliance of an effective I have
425.
425. Thank you. I'm dyslexic, so numbers flow a bit. But a 425, one that has been filed. What is the provenance of the primary jurisdiction of the SBC to delve into the efficacy of an effective contract?
Well, that's just it. It's zero. They have none, Your Honor. There is no basis in any statute, and appellees cannot point to one, where it ever grants the Boundary Commission the authority to look into the validity of one of these agreements.
Do I understand you correctly to be advocating the preservation of Casco?
None, not whatsoever, Your Honor. And perhaps I misunderstood the question.
I thought, maybe there's another. So I thought the argument was that the invasive aspects of that decision that suggest that it is appropriate for the SBC to challenge the provenance of an effective 425 agreement, that was dicta, and therefore we didn't have to worry about that decision. That's not you?
That is me. My position is, one, they don't have the subject matter jurisdiction to make that determination in the first place.
But you want to keep Casco in place?
Absolutely not.
That's not what you said.
Okay. All right. Is it dicta or not?
The jurisdictional holding is not dictum. The rest of Casco Township is dictum, because the issue of whether the Boundary Commission's decision in that case was supported by adequate facts was not even on appeal. The townships in that case conceded that they did not even challenge the underlying factual findings of the invalidation. So that whole part of Casco Township is dictum. Nonetheless, I think it would be important for this court going forward, when jurisdiction over Act 425 agreements and their validity is properly vested back in the circuit courts, to provide instruction that that is not binding language, because it is so off the rails from the plain text of Act 425.
You concede it seems to be pretty hardwired that when there's a challenge to the propriety of the 425 agreement, that the SBC is now thought to have jurisdiction over that matter?
That's what Casco Township holds, certainly.
So did you challenge did you raise this jurisdictional argument before the agency?
I did not raise this.
Or in the Court of Appeals?
I did not raise
And so why should we hear it now?
Because this court always has authority to hear challenges to subject matter jurisdiction.
Yeah,
They
that
are not
would be
waived.
true if the agency were a court. But what is the difference between, with an agency, which, as you say, gets all of its authority only from statute, what is the difference between saying an agency misapplied the authority it was given by statute, or the agency acted beyond its statutory authority?
I think there's a grave distinction between those two things, Your Honor.
Supreme Court of the United States disagrees with you.
I'm sorry, I was talking.
So the Supreme Court of the United States disagrees on that question.
They have
City of Arlington versus FCC.
Yes, the federal courts recognize Chevron deference, which allows an agency to make initial determinations about its own jurisdiction. This court soundly rejected Chevron deference.
Yeah, sure. So that goes to the reason why one reason why you might want to raise a question in the agency, but it can't be the only reason why. I mean, the question we're trying to figure out is whether there is any distinction you can make in your mind between subject matter jurisdiction and ultra vires authority when you're talking about an agency that gets all of its authority from a statute. So, I mean, we have to be able to do that puzzle. And I don't, in order to allow you to bring your abandoned claim here, because this is a jurisdictional claim, I have to be able to sort jurisdictional claims from plain, I acted beyond my statutory authority claims. I misinterpreted my statutory authority claims. And I don't know how to do that math.
Well, I think I can pose a hypothetical to you that would make it clear. If the Act 425 statute said, quite expressly, the Boundary Commission has the authority to review and determine the validity of Act 425 agreements, then it would have subject matter jurisdiction. But if it then went through a hearing and invalidated the agreement because, for example, let's say the agreement didn't include provisions about police service, well, that would be an ultra vires exercise of jurisdiction because Act 425 doesn't say anything that you're required to have provisions about police service.
Right.
This is quite different. Here you have the situation where the Boundary Commission is not empowered to do anything in the first instance, so there's not a secondary question here of whether they can apply their authority in some way.
So I don't, I don't know why that's different than saying, so they have to do something. They have to cease their proceedings, right? They can't just, they have to do something with respect to a 425 agreement because once there is one, they can't do anything. So the question is whether they can determine that it is a 425 agreement. Now you say no. That's correct. You might be right about that. But what I'm trying to figure out is whether that's a jurisdictional question as opposed to a lack of, I misinterpreted my statutory authority question.
Under the clear precedence of this court, it has always been treated as a jurisdictional question, as a threshold issue, that there must be clear and unmistakable language in the statute that grants the agency authority to act.
So let's just take an example, an environmental example. So if I say the Clean Water Agency has the right to regulate navigable waters. That's their jurisdiction, and they interpret, as the U.S. EPA has done, navigable waters to mean ponds, puddles. I could say they are, and I think that's wrong. Let's say I think that's wrong. I could say they have exceeded their jurisdiction when they regulate my puddle, or I could say they have just misapplied their statutory authority when they regulated because they misinterpreted the word navigable water to mean puddle. Isn't that the exact same thing? So if you're an agency, I don't know how I slice jurisdiction from you misapplied your authority.
Respectfully, Your Honor, that is not a comparable situation because the navigable water you're speaking of doesn't exist in statutory form here. I concede to you
that it does in my hypothetical.
Right, and that's my point. In the case we're dealing with, the metaphorical counterpart does not exist. There is no grant to the Boundary Commission of jurisdiction over navigable waters. There is no grant of jurisdiction to do anything with respect to 425 agreements.
Except cease their proceedings when there is a 425 agreement. And what I need to know is, like, So the agency comes in and it writes, so you come in and you write on my notepad, 425 agreement. And then, like, I should just go, oh, I see, somebody wrote in crayon 425 agreement, it's a 425 agreement, or do I have to know that it is a 425 agreement?
What you have to know, Your Honor, in that hypothetical is that you have been put in front of you this letter that is issued in every case where an Act 425 agreement is executed, that the Secretary of State has determined that there is an effective Act 425 agreement. And what they have to do,
so even if you're right about that, you would be saying that my statutory authority, that I should interpret the statute to say, if this thing has been filed, then I must cease. But I still don't get why that's a jurisdictional question that you didn't have to raise below, as opposed to an interpretation of the statutory authority question.
Could I ask, isn't part of the problem here that our cases by the Court of Appeals have made this question of who gets to decide the provenance of an Act 425 agreement within the primary jurisdiction of the Boundary Commission rather than the circuit courts that usually would have jurisdiction over these matters?
You're correct, Your Honor. It should be exclusive jurisdiction.
Now, but let me ask you, what does the fact that you didn't preserve this question have? I mean, I think that there's a distortive impact. I think the matter should probably have been decided by the circuit court because I don't think if there's an effective act, the commission does not by statute seem to have any authority over these contracts. But the whole problem has been we've said, well, they get to decide that question. But so now tell me why, notwithstanding your failure to raise the jurisdictional problem, we should entertain that problem.
The reason you should entertain that problem, Your Honor, from a broader perspective, is so that you don't have an agency going forward that is making decisions that is not authorized by law to make. You would, in effect, be endowing.
I might agree with you, but don't you have to do some heavy lifting here and say, I'm sorry, I'm objecting to your jurisdiction, SBC. You don't have any. Your jurisdiction is as soon as the Secretary of State certifies there is one in an Act 425 agreement in effect, and that's a matter for the circuit court, not you?
We did raise the argument that it barred them from proceeding further after the legal sufficiency hearing. We filed the Act 425 agreement and the Secretary of State's letter at the legal sufficiency hearing and said, you can go no further than this.
Okay. Did you preserve the jurisdictional question or not?
I believe that that's sufficient for preserving it, notwithstanding the fact that this Court has held time and time again that questions of subject matter jurisdiction cannot be waived.
Have we ever held that with respect to an agency in particular? I mean, we say that all the time about courts, and there's good reason for that because it's a constitutional question. But
from a philosophical position, Your Honor, I would find that spectacular to treat agencies different in that respect because I would find it to be a questionable exercise of judicial authority to allow an administrative agency to act by judicial fiat outside of the authority it's been given by the legislature to say that it would be treated differently than a court.
I would agree with you if I thought we could figure out what's the difference between acting beyond statutory authority and misinterpreting your statutory authority.
What's the best case for the Michigan rule concerning the statutory authority of agencies?
Most recently, it's the Haring District Library case, and that's a Court of Appeals decision, but it cites all of
Do you have a Supreme Court case on that point?
Yes, Your Honor. I'm sorry. I don't have it in front of me right now.
I'm trying to think of most of these arise in the tax arena, where I believe the court has said, unless there's statutory authorization for the agency to act, it has none.
That's correct. That rule is so firmly.
Where's I can't think of the case off the top.
There's Sizmore's timber case is one of the ones cited in in Herrick Town, in the Herrick District Library case.
Right, but, yeah, fine. I just don't know why you didn't need to present that claim below.
The fact is, there is repeated precedence from this court that subject matter jurisdiction cannot be waived, Your Honor. And there's
But you
good
can't
reasons
point
for
me to
that.
one that says that with respect to an agency. I mean, maybe there is one. I just haven't seen it.
Your Honor,
Well, did you make, I'm confused. I thought at some point you said you raised the challenge to the SBC's authority to decide the question, and then what is it? Did you waive that argument or not?
I don't believe we did, because like I mentioned, at the legal sufficiency hearing, we did file the Act 425 agreement, the letter from the Secretary of State's office finding that it's in effect, and said you can go no further.
Okay, well, they
and
did.
in reliance on Casco
They did. Now
Township.
the next level,
Okay.
did you appeal the subject matter jurisdiction at the next level of appeal?
We made the same argument in this respect, Your Honor, that they should have, at the point of receiving the Act 425 agreement, suspended the proceedings at that point.
Well, why do you say that? Are you contending that you did preserve the issue on appeal or not?
Your Honor, what I didn't do is because Casco Township was controlling on the courts below, I wasn't going to argue to them that Casco Township was wrong in its jurisdictional holding. Because
Why not?
Because
don't you waive it then?
No, not a subject matter jurisdictional challenge, Your Honor, because a governmental entity can never gain jurisdiction over a subject matter through the waiver or acts of a party. That's tantamount to.
I'm still trying to understand exactly what you think you did, because on the one hand, you're saying you argued the underlying premise that Casco Township got this wrong, because if you made the argument to both the agency and the court below that the agency had no business doing anything other than shutting down its consideration once it was clear that there was a 425 agreement, that's kind of saying Casco Township was wrongly decided, without saying Casco Township. Were you just trying to be polite? Like what?
I was spending my time on more important issues in light of the fact that those lower agencies and courts were bound by Casco Township. So in those courts, I am yelling at the wind to say Casco Township was incorrectly decided. So you raise the underlying issue, guys, you got the Act 425 in front of you, you should be done. But no, I did not raise the argument Casco Township is wrong for reasons A, B, and C, because that doesn't matter to the Boundary Commission.
You did challenge the authority of the SBC to consider the propriety of.
You just didn't put it in the frame of Casco Township was wrongly decided.
Correct, because there would have been no point in that. I took the position that they should, when the legal sufficiency hearing occurred, that should have been the end of it, because they should have found the petition to be legally insufficient in light of the presence of the Act 425 agreement. Your Honors, if I could move on to the second part of the case, because I'm sure my time is running out.
Sir,
that's,
sir, can I ask you one more question, please? If questions of subject matter jurisdiction can always be asserted in connection with an Article 6 judicial body, would that same proposition, in your view, hold equally true or more or less emphatically with respect to an administrative agency created by the legislature?
I think it's equal, Your Honor, but it comes from a different premise, because typically most courts are acting on a constitutional basis for their authority, whereas agencies are wholly creatures of statute and therefore can't do anything that a statute doesn't provide. So your tier of analysis in many respects is different with the positive law you're dealing with.
Well, there's a different fundamental authority. There's a different premise for objecting to jurisdiction, but it sounds to me like you're saying that in the case of a legislative creature or creation, that there's even a more strong and emphatic argument that such jurisdiction can't be waived.
Well, yes, certainly, because with an agency, they have nothing that the legislature doesn't give them. So there's a presumption that unless there's some affirmative grant, it does not exist. And that's the point I was making with a court. They start with some threshold of constitutional authority that they're granted that can be modified by statute. So you've got a broad penumbra that a court operates.
Possibly some measure of inherent authority
yes,
as well.
Whereas an agency is presumed to have nothing that's not expressly granted.
Have
by
you
statute.
made that argument in your brief?
Oh, most certainly, Your Honor, not in the sense of comparing a court to an agency in different levels
That's
of
the whole,
review.
that's the whole premise of my question.
You have 5 minutes. Do you want to continue or do you want to reserve?
I want to continue, and I'll spend it
Okay,
on
so-
the other docket number, if I may, Your Honors. And I want to take another risk here, if you will, and that's to argue to you that this case should be decided solely on grounds of severability. And I say that's a risk because I know this makes it very easy for the other parties to stand up and say, well, you're only doing that because you're really conceding that your development standards are invalid. Certainly very easy for them to do that. But that's not the case at all, Your Honor.
This goes to the question of whether an Act 25 agreement can provide for zoning ordinances?
Yes, I'm on to the separate docket number, Your Honor.
So you're not conceding that they can't, are you?
Oh, absolutely not, Your
So
Honor.
you're just making an arguendo. If we don't agree with you, then the way the substantive resolution of that question below was inappropriate.
What I'm arguing is in the consistent theme of sound conservative jurisprudence concerning the judicial power, that it is the most advisable thing for a court to decide a case on the narrowest and least divisive grounds and to avoid broad, unresolved questions, making pronouncements that will have effects outside the contours of this case, when a case can be decided on well-established, well-worn principles of contract law that control this dispute. And here you have a case, Your Honor, where it is undisputed that the townships, who I remind the court respectfully, are the only parties to this contract, undisputedly and universally agree that the development standards of their agreement are immaterial and can be stricken. It would be unprecedented for this court to say that a stranger, as such as one of the appellees here, can stand on the sidelines and say, parties, you no longer get to decide what provisions of your agreement are material to you. Me, as a stranger, TeriDee, I get to stand here on the sidelines and tell you what is and is not material to your contract.
So let's explore the stranger to the agreement thing. Do you think that she even has any ability to challenge the validity of the 425 agreement in the circuit court?
I raised that argument in the circuit court repeatedly at every level, that there was not even a justiciable dispute here where the parties to the contract agree to its meaning. It's universally accepted that their interpretation is lawful, and a party cannot sit on the sideline and say, parties to the contract, you're not allowed to have a lawful contract. As a stranger, I get to stand here and
so I get that. I mean, that makes sense to me. Like, it's bizarre that a non-party to an agreement, a stranger to the agreement, can challenge the terms of the agreement, and she's not the entity is not a third-party beneficiary. Quite the opposite. However, your jurisdictional argument in the other case means the SBC can't challenge the validity of the agreement, where TeriDee would be a party. And then the argument is you go over to circuit court to challenge the validity of the agreement, except, TeriDee can't challenge over there either. So there's no place. So that's awesome for you because you absolutely win no matter what.
That's not my position, Your Honor, because there's two distinctly different issues in the two cases. They do have jurisdiction, and I would concede, to challenge whether the agreement complies with Act 425 in the circuit court. What they do not have.
Why?
Why? Because,
why does she? I keep saying she. It sounds like a she, TeriDee.
It's actually the developer's wife's name combined together, so you're close to correct.
All right. Why does the entity have standing in circuit court to challenge the validity of an agreement to which the entity is not a party? I mean, could I show up and say, like, hey, this doesn't look like a 425 to me? I've never been to Clam Lake. I'm sure it's lovely.
I think the standing jurisprudence that's been established in this state would allow a court would allow a party to challenge the validity of a contract, whether it complies with a statute that's for the public benefit, when they are claiming some particularized harm. Now, that's quite a different thing from saying the parties, you can't have your own interpretation of the contract that you have both agreed to, and a stranger gets to say what the contract means. What it means is a different thing from, is it valid? And I do think they can come into court and say this doesn't comply with the statute. What they cannot do is come into court and supplant the intent of the parties and say, no, stranger, I get to say what your contract says, not the actual parties to the contract. Those are distinctly different principles.
I'll have to think about that.
Thank you very much.
Thank you, Your Honors. I appreciate the time you've offered today.
Good morning, and may it please the Court. Brian Doyle on behalf of the appellee TeriDee, LLC. With me today at council table are Patrick Fitzgerald with the Attorney General's Office on behalf of the State Boundary Commission, and Michael Holmier on behalf of appellee, the City of Cadillac. Justices, appellees have elected to divide their time equally, 10 minutes each. We'll manage our own time.
Yes, you will.
And in terms of a roadmap.
You saw how well that went last time.
In terms of a roadmap, Justices, I intend to primarily cover the invalidity of the agreements, as was decided below, and the authority of the State Boundary Commission. Mr. Fitzgerald also intends to cover the authority of the State Boundary Commission, as well as the doctrine of collateral estoppel. And Mr. Holmier intends to cover the doctrine of stare decisis, including practical workability. And we'll see how our plans actually turn out in terms of what we intend to cover. I want to make a brief opening statement and then waive the remainder of my uninterrupted time. As counsel for the developer, I'm concerned less about the long-term implications for municipal law in this state than I am with seeing the decisions below that affect my client's annexation, the annexation of my client's property and the agreement upheld on appeal. That being said, I do support and I've argued in favor of the continued application of the rule that was articulated in Casco Township. That rule of law goes back 15 years to Casco. It actually goes back 15 years before that to this court's decision in Shelby Township, and ultimately before that to the broad grant of legislative authority to the State Boundary Commission with respect to annexations. In particular, Section 9 of the Home Rule City Act provides that the legislature has given the State Boundary Commission the authority to determine the validity of an Act 425 petition and to approve, deny, revise, process that petition. That same authority is set forth in the State Boundary Commission Act, MCL 123-1011A. And of course, Act 425 provides that when a contract under this Act is in effect, another method of annexation shall not take place. So those three statutes provide the State Boundary Commission with the authority to determine whether it has a valid bona fide Act 425 agreement before it, an agreement in effect under the statute. In other words, the legislature has said to the State Boundary Commission, we want you to decide whether to approve or deny a petition. In order for the State Boundary Commission to determine whether it should approve or deny a petition, it must necessarily decide when it's presented with an Act 425 agreement, is this an agreement in effect under this Act? Is it a valid agreement? But again, my primary concern is the result as it affects my client, the owner of the property. And there's been some argument, which form was proper here? Well, ultimately, we went to both. The State Boundary Commission decided this is not a valid Act 425 agreement. It's not an agreement for the purpose of economic development. That's the statutory requirement. It was enacted for the exact opposite agreement, to prevent development. That decision was then affirmed by the Circuit Court. Separately, the Circuit Court also held that the contract was void, as impermissibly delegating away legislative authority. Both of those decisions are supported by competent evidence. And on the latter point, while I certainly argue for the continued application of the rule last articulated in Casco, it's a moot point in this case. The Circuit Court determining that the agreement was void means that while the State Boundary Commission didn't know it at the time, they never had an Act 425 agreement in front of them. A void contract is a contract that never existed in the first place. So it's a moot point in this case as to it's not an issue that is actually before the court. In addition, regardless of if the law changes, the townships can never prevail here because not only did they not raise the issue at any point on appeal, at any level of appeal until this application stage, that the State Boundary Commission lacks authority, they argued just the opposite, and they prevailed on that argument. They argued that, in fact, the State Boundary Commission has statutory authority, is uniquely suited, and must necessarily decide the validity of an Act 425 agreement in any annexation petition. Moreover, in this case, the Act 425 agreement was filed 5 days after the annexation petition. And even if, to get to the point of whether it was in effect, even if that late filing, it could still be in effect. In effect is only, under the statute, prima facie evidence of the validity of the contract, which can be rebutted. And with that, Your Honors, I'd like to waive the remainder.
You said something that at least I must have missed in my own review. You said that the authorization statute for the SBC gives them explicit authority to inquire about the propriety of an Act 425 agreement. What is that provision?
Justice Young, what I referred to is Section 9 of the Home Rule City Act. That's MCL 117.9, subsection 2.
Say that again.
MCL 117.9, subsection 2, Justice Young, says the State Boundary Commission has the authority to determine whether a petition is valid. One of the reasons a petition...
Wait a minute. I thought, correct me if I'm wrong, the exclusive provenance of the SBC was to determine annexation petition.
And that's, when I say petition, I mean annexation petition.
That's what I thought.
Yes.
Okay. Now, as I understand the universe, while seems to be a great deal of bile directed at Act 425 agreements, but from the judiciary and the SBC because they oust the jurisdiction of the SBC if they're effective, that's really what the legislative policy is. They are designed to prevent larger communities from taking portions of smaller communities. It allows them to band together. Do you disagree that that's a fair characterization?
I would argue, based on the legislative history, that they were designed to promote cooperation among townships and developers.
And to fend off annexations.
If
that weren't true, it wouldn't be a stopper to the SBC's ability to make an annexation approval that is opposed to an existing 425 agreement, right?
It's correct that economic development is a desired goal, and to promote that cooperation among townships, municipalities, and developers, if there's a valid Act 425 agreement, there's no doubt that that precludes another method of annexation.
So what we're really talking about then, it's like two different universes. It's either Act 425 or the possibility of annexation. They cannot coexist.
A valid Act 425 agreement, there cannot be annexation.
All right. Now, the issue that seems to be posed by this case is if there's challenge as to the validity of an Act 425 agreement, who gets to decide that question? And I'm now searching for the authority, clearly plenary authority of SBC to decide whether an annexation petition is valid. I don't know the corollary. They have the right to inquire as to the validity of an effective, that is filed, 425 agreement.
And what we argue is, in order to determine whether they have a valid petition, a petition they can move forward with and then decide should we approve or deny, to determine do we have a valid petition for annexation, when someone then, after that petition is filed, files an Act 425 agreement that has only prima facie effectiveness.
Well, prima facie meaning what? The secretary?
Rebuttable.
No, I understand what the term is. I'm trying to understand what it means in this context. If the SBC is presented with the certification of filing by the Secretary of State, what further inquiry rights does the SBC have to determine whether the contract itself is valid?
The Secretary of State, there is no indication, does any sort of substantive review of the agreement.
Agreed.
So,
agreed.
For the townships to argue that once the SBC is presented with anything labeled Act 425, they have to run away from the annexation proceedings, that's an obtuse reading of the statute that thwarts the legislative intent. The legislature intended for the State Boundary Commission to decide the validity of an Act 425 petition. One reason it may be invalid
But how do we know that? How do we, tell us where we can derive that.
MCL
legislative
117.9 says, the legislature has said, the State Boundary Commission has the authority to determine the validity
Of a petition.
of an annexation petition.
Right, that's not, but we're not talking about the validity of the petition, we're talking about the validity of a 425 contract.
Which you say the legislature strongly intended the SBC to be able to determine. We're just saying, where do we find that? How do we know that?
It would thwart the legislative, again, for the townships, as they did here, to present a sham agreement, and it's been obvious to everybody that's reviewed it that it's a sham agreement, for them to be able to present a sham agreement and ward off not only annexation and development, but to ward off the SBC, that would again thwart the intent that they have plenary.
Well, if it's oh, I'm sorry, Steve. No. Go ahead.
Well, not only is there an absence of any kind of explicit assertion of jurisdiction of the sort that you're suggesting, but as a logical matter, as a logical approach, why would it conceivably be the case that the same agency, as the Chief Justice just mentioned, whose powers are apparently being circumscribed by Act 425 agreements, would have jurisdiction to determine whether or not its own powers have been circumscribed? Why logically would that flow from any kind of reading of Act 425?
Justice or otherwise.
I'm sorry.
I think you thought that would be a crabbed construction. So,
well, and I do want to be mindful of my colleagues' time, and I'll try to address that last question, Justice Markman. I mean, this court has long held that agencies are competent to look to see whether they have the authority to decide an issue. But again,
yes, but you can determine that by the fact that the Secretary of State has certified that there is an effective act. What you're concerned about is whether that's valid. That's a different question entirely. And the question I think is really important to us is, assuming this issue hasn't been waived, is who gets to decide it? The regnant law created by the Court of Appeals is the SBC has the subject matter jurisdiction to determine whether the Act 425 agreement is valid. That's kind of like the fox being able to determine whether all is okay in the hen house, isn't it?
And it's a big statement, right? It's a big statement to say an agency is competent to determine its own jurisdiction. I mean, can the SBC determine, whether we should regulate Justice Larson's puddle? I mean, come on. I mean, there have to be some limits to that.
Again, when the legislature has said, as this court said in Owasso Township, the SBC is to have a comprehensive authority with respect to annexation.
For a particular purpose, for annexation.
So this fox hen house problem is a problem. It's just a problem that inheres in all entities that have to decide their own jurisdiction. Like if a court, for example, decided that it did or did not have jurisdiction, that would be a fox hen house problem, right? But we decide our jurisdiction all the time.
I would agree with that, Justice.
So not all fox hen house problems are fatal. The question I might have, I mean, that doesn't mean that you're right. It just means that the fox hen house problem can't be the whole problem. If the SBC had authority to decide this question, would there then be judicial review of that question?
There would. What the SBC does is it makes.
Why is that a better system? I mean, I guess you're arguing for a better system than the system advocated by your opponent, which is that Secretary of State files, it's prima facie valid, then go to circuit court and let the circuit court decide it. Why isn't that just
that would effectively end annexation in the state, and that's not hyperbole.
Wait, why would it?
We've seen that play out in this case. We had townships here that reacted in real time because we were challenging in both on different grounds. In the circuit court, as the circuit court judge would issue partial rulings for summary disposition, the townships would go and amend and tinker with their agreement to react in real time to try and buttress their sham agreement. You can imagine
this. It's inefficient. I mean, you've got to go to the circuit court, get a determination that it's valid or if it's valid or invalid. If it's invalid, then you can go over and start your annexation.
You take that back to the SBC, and in the meantime, the townships have enacted a second agreement.
And the point is what? I mean,
it would create an endless loop.
Is there a policy of the state to favor annexation or not favor it? Is there? I mean,
there is not.
Okay,
there is not.
So why do we care if it disfavors annexation?
That goes to the stare decisis. There's no practical workability issue here.
Stare decisis
what?
Well,
The alternative
What are
is-
we talking about as stare decisis? Is
what
there a
decision
Supreme
of our
Court
court do we
case
have to fix?
involved here?
Well, again,
Does
I don't-
stare decisis apply to lower court decisions?
It does not, but it would apply to Shelby Township, which, but I'd like to see the rest of my time, Your Honor, justices, to State Boundary Commission.
May it please the Court, Assistant Attorney General Patrick Fitzgerald, on behalf of the State Boundary Commission. I had prepared some remarks, but I'd like to begin jumping right into the issue that the Court mentioned. I think a point of clarification is ordered in regard to when and whether an Act 425 agreement is, quote, in effect. And I would draw the Court's attention to Section 9 of Act 425, which refers to when an annexation agreement, or pardon me, when an Act 425 agreement is, quote, in effect, no other method of annexation shall take place. I would also distinguish the language appearing in the in Section 10, just below, which talks about the filing of an Act 425 agreement constitutes prima facie evidence of a transfer taking place, not at all to the effectiveness. So what, in fact, the townships received from the Secretary of State's office is an acknowledgement that a, quote, transfer has taken place.
So when does a 423 become effective?
Or a 425.
I'm sorry.
Either way.
Sure.
Well, the contract, I'll use that now. When does the contract become effective?
A contract its effectiveness depends on whether it's valid in the first place. So if upon the filing of a 425 agreement, whether it's written
So
in
the filing is a fairly significant thing, where transfers of
unless
occurred.
the townships or the municipalities were to have reserved or to assign otherwise jurisdiction over the territory covered by the 425 agreement, as is contemplated in Section 8 of.
I'm trying to figure out how the cow eats the cabbage here, because we have on the one hand an authority, your client, that has plenary apparent statutory jurisdiction over annexation, that is in fact seems to be ousted if there's an effective contract, right?
I wouldn't agree with the statement that that Act 425 agreement divests jurisdiction.
I'm just saying, if we have an effective contract, leaving aside the propriety of that determination, but if it's effective, your client has no jurisdiction, correct?
My client does have jurisdiction to resolve an annexation petition.
Yes, but it doesn't have, if there's let's say there's a judicial determination that the the contract permitted under the Act is valid, effective, your client's jurisdiction is to deny any annexation petition, correct? It has no other alternative under these statutes.
I disagree with that.
Okay.
And I would distinguish between a situation where some subsequent act would have the effect of divesting jurisdiction, where the commission has no authority to do anything, not even to deny the petition, but to simply throw up its hands and say, we have no authority.
But under the Chief Justice's hypothetical, if it's been adjudicated by a court to be there's no a valid 425 agreement, is it your view that the SBC still can override that finding?
I would
is that efficient that we are always litigating this in two fora?
I don't even talk about efficiency. Is it statutorily authorized for your client, after a judicially adjudicated effective 425 agreement is in effect, to do anything other than deny any annexation that would affect the property covered by the agreement?
Again, I would clarify that a 425 agreement has been filed. The validity was questioned, was subsequent.
You were resisting. You can do that. You can just tell me, Bob, I don't want to answer your question. But my question is.
I find your hypothetical unhelpful, Bob.
Yes. Is that your position?
No.
I don't want to answer your
It's helpful,
hypothetical?
so you
Please.
might want to just answer.
My hypothetical is, there is no question about the efficacy, the effectiveness of the 425 agreement. Period. End of quote. No dispute. What is the authority now of your client?
The commission if faced with a petition for annexation under its jurisdiction
Yes.
covering the same
Same
territory,
area, yeah.
where the commission recognizes that there is an agreement in effect that provides for an economic development
Do you
purpose.
get to inquire into any of that now? If what I put to you is those questions are beyond dispute,
It's valid. We all assume it's valid. Your co-counsel conceded this.
but he's having difficulty, and I want to know why.
No. I would resolve it this way. My position on behalf of the State Boundary Commission is that the commission has jurisdiction, as the Court of Appeals in Casco previously said, to decide the question of the validity of a 425 agreement in this context. In the alternative, though, I think the court can look at this as a situation where the commission may proceed at its own peril. It may process a petition subject to whatever challenges, collateral or otherwise.
So it can act ultra virus.
I wouldn't concede that it's ultra virus. I would say that the commission has simply made an administrative determination.
Just distracted you enough. Proceed with your argument.
Well, I haven't distracted you quite as much. Under MCL 130, or MCL 124.30, once those procedures have been followed and a 425 agreement is apparently in effect, is your authority triggered only when there's a presumed sham 425 agreement, or is it triggered by what larger standard of review?
The commission's authority is triggered when there's a petition filed covering the same territory that is covered in a 425 agreement.
And the 425 agreement fails to meet what standard?
As it turns out, it's the exact same standard for a 425 agreement that the commission considers in an annexation petition. So, as I was about to argue, I think that the Boundary Commission is optimally situated under the doctrine of primary jurisdiction as a state agency vested with specialized expertise over such matters.
So in no reasonable circumstance could we ever expect that a 425 agreement would be successful in limiting a proposed annexation in that same realm. In other words, that would necessarily be either a sham or you would have jurisdiction nonetheless over that same territory in any event, whether or not it was a sham.
And I think that possibly yes. And I think that question
It could never be used to check an annexation.
The commission, I believe, would have the authority to decide.
Okay.
Where does the commission get this broad authority? What statute? Your co-counsel points us to the commission's very broad authority to determine the validity of annexation petitions. I'm still struggling to find a similar statute that gives it this broad authority, as you've described it, to even disregard a circuit court ruling on the validity of a 425 agreement and to still do whatever it deems appropriate. That's pretty broad authority. Should we get that just as a feeling that the legislature thought this would be better because your client has expertise in this area, or don't we have to find some statutory basis for this?
Justice Viviano, I would refer the court to the same sections of the Home Rule City Act and the State Boundary Commission Act that's already been discussed today.
So there's nothing specifically on point, like there is for annexation agreements.
Correct. The Boundary Commission Act, as this court has recognized, vests the commission with broad authority over annexation matters, and that's the only statutory authority I can refer you to. What I would like to clarify, though, is in this case, the circuit court, in fact, decided on separate grounds through a declaratory action initiated by TeriDee and determined that the agreement was void.
Based on the findings of your commission, right?
No, incorrect.
Okay.
The circuit court determined that the 425 agreement was void as against public policy on grounds that it unconstitutionally delegated the township's zoning authority.
That's the second issue. Okay.
Right. It's also important to note that the circuit court recognized at the outset, during the pendency of the annexation proceeding, before the Boundary Commission made any decision.
Are you the one that's addressing the delegation of authority question?
Sure.
Okay, explain to me why a statute, 425, that expressly authorizes local governments to negotiate and agree on ordinances without limitation cannot also agree to the zoning ordinances. There's no statutory prohibition, correct?
Correct,
Okay.
Justice Young. This issue, in fact, was in a case that the State Boundary Commission wasn't involved with, so I misspoke.
That's why I asked you the question.
I didn't know
Perhaps you're under 5 minutes.
Thank you. If
Perhaps
I may
somebody who
reserve-
can answer that question might want
Yes.
to do so.
Thank you.
Justice Young, I'll come back up to answer that question. What the townships are arguing is the language in Act 425 that says, I want to quote the provision.
I'm aware that it allows them to.
For the adoption of ordinances,
Ordinances.
they say that that language means that for the first time ever in the jurisprudence of this state, two townships can enter into contract zoning where one can bind the other, something that's otherwise been declared on multiple occasions by the court to be unlawful, illegal in creating a contract void. There is nothing about the language.
But those agreements also permit them to alter those ordinances. There are all kinds of provisions in the Act that are mandatory that require them to be able to modify their agreements.
The provision says you may provide for the adoption of ordinances and their enforcement.
And there are other provisions in Act 425 that permit them to modify those.
There's nothing in Act 425 that would permit one to bind the other. There's only two limited instances in all of Michigan jurisprudence where parties may bind another in contract zoning, and that's always a township on the one hand, a developer or property owner on the other, never two townships. Both of those instances are in the Michigan Zoning Enabling Act, where the townships get all of their zoning authority. So there's nothing that would say that this would override that authority. Thank you.
Good morning. May it please the Court, my name is Michael Homier, and I represent the City of Cadillac. As I suspected my colleagues were going to use up most of the time, I'm going to get right to the point, and that is I practice in the field of municipal law. We represent hundreds of municipalities. We have relied on Casco for 15 years since its adoption. To get to your point, and I think to summarize the points that have been made.
You realize that stare decisis is not, you may have policy arguments to make, but you realize that stare decisis is not among them for a Court of Appeals case.
I do understand that, Your Honor. However, I would argue that the same points are at play here, which is, this does not defy a practical workability here. This has been the issue. The whole issue about the 425 agreement and whether it is in effect, counsel for the township said, well, the sole purpose of 425 is to keep the SBC out of it. No. The whole purpose of 425 is for economic development. And what the townships are doing now is they're using that act to thwart economic development, which is what the Boundary Commission determined.
But isn't the real question here, who gets to decide whether those agreements are for a valid or an invalid reason? And that's what the Court of Appeals has determined is that is the bailiwick of the SBC rather than the circuit courts that ordinarily would decide such questions.
Yes, and I think that's right. And I think it depends on how you interpret the word in effect and what that means, particularly for the Boundary Commission, who has to determine, and this gets to Justice Larson's point, does the Boundary Commission accept any and all document as a 425 agreement and say it's in effect? Was it noticed properly? Was there a referendum on it? Were there all of these things that can happen?
Why isn't this?
Can a court figure all that out? Why do you think the SBC is like especially in the best position for that? All these things that seem to trouble us about this particular 425 or trouble you? We're just listening. What's wrong with bringing them to the circuit court and
I don't.
sorting them out?
Yes, and I don't necessarily disagree. And I don't necessarily disagree that the court can't find that on future cases that should be the case. The reason why this one is different is because the townships not only waived their argument, they specifically argued that the SBC had jurisdiction and was uniquely situated to rule on that. And they argued that in the circuit court.
So what should we do about that? There's an argument in here about judicial estoppel, but no real remedy was suggested. I mean, what if we were sympathetic to that? What would we do?
Well, I think that in terms of, a change in the law, that could be applied prospectively, but not in this case. And the reason for that,
Do we have the right to make an ex cathedra decision that applies
no.
to nobody in the case?
No, I think
that's right.
Well, but I think what happened here, as my colleague mentioned, it doesn't really matter because there was an SEC determination that the agreement itself did not promote economic development. That case went to appeal to the circuit court, who decided that, one, it was authorized by law, and that the SBC's determination on those issues was supported by competent material substantial.
That's an appellate standard.
I understand that, Your Honor. I understand that. But now combine that with the original action that the developer also bring in circuit court, and it was set aside again. I mean, it's been reviewed so many times and set aside so many times, it would be difficult, I think, in this instance, to look at this case and say that there weren't enough people looking at this agreement to decide that it did not promote economic development. And that is the real issue here.
Does the SBC have the authority to call a 425 agreement into question on the basis not only that it thwarts economic development, but also where it facilitates economic development, but to a lesser degree than an alternative annexation plan would?
No, I don't think so. I don't think that the SBC is deciding, well, this economic development's enough, but this economic development is better, and therefore one's a sham versus the other. I don't think that was a point, and I don't think the SBC made that point. What the SBC said was...
That wasn't precisely the point in this case.
No, it was not precisely the point. Precisely the point in this case was the townships, and this is a second go-around, where they have tried to prevent economic development. And I know I'm out of time.
So that's just not a legitimate objective for townships to be pursuing?
Not under Act 425, not to thwart economic development. The whole purpose is that they can join forces and promote economic development. And that's not what's happened here for the past 10 years. It's been a decade where they've thwarted that economic development. And I think it's troubling now to use that act to thwart the not only annexation in this case, but the overall economic development.
Thank you very much.
Thank you.